So very quickly, we'll be moving on to calling our panelists and our moderators for this panel session. Our scene setter for today is an energy lawyer who works in the firm B&I. His name is Mr. L.E.I.C.A. He has over a decade of experience advising clients on complex oil and gas transactions. Please put your hands together for our scene setter, Mr. L.E.I.C.A, as he comes to the stage. Thank you so much. All right. Our first panelist for this morning is no other than the Commissioner, Legal Licensing and Compliance, Nigerian Electricity Regulatory Commission. Please welcome with me with a warm round of applause, Mr. Daffy Akpeneye. Thank you so much. Yes, and apologies. Earlier on, I was referring to the representative of the NMDPRA as Mr. Please note that the representative of the NMDPRA is Dr. Joseph Tolorunji, and he is an esteemed panelist on the very first panel session for this conference. Please put your hands together for him as he comes forward. You're welcome, sir. On this panel, I also have the Deputy Director and Head of Regulatory and Statutory Compliance at NUPRC. Please welcome with me Mr. Kingston Chikwendu on this panel. I also have on this panel, to do justice to governance, regulatory compliance, and institutional reform, Mrs. Lois Oni, Head Counsel, Litigation and Regulatory Compliance at NLNG. A round of applause for her as she comes forward. To moderate this panel, I have the partner at ENR Advisory. Please welcome Jumoke Fajemi with a warm round of applause as the moderator for this panel. You're welcome. And so the panel will follow this fashion. Our scene setter will come to the lectern, and for 15 minutes, he will give his presentation, and then Madam Moderator will take it up from there. Thank you so much. Once again, a round of applause for our esteemed panelists. Thank you.
Good morning, Chairman BOT. Good morning, members of the planning committee and all panelists here present. Again, my name is L.E.I.C.A. I work with the firm of Bawa Nigudalo, and I have the very privilege to set the scene for this panel session. I think that this topic couldn't have come at a much better time than now, given the different developments in the sector, both for the power sector and the oil and gas. It's critical to recognize the efforts of the regulators in pushing reforms that truly reflect the growth that we would like to see. Dovetailing from what the chairman of BOT had mentioned earlier, we've seen steps from the NUPRC in engaging stakeholders to be part of regulations that they issue that would govern the sector, that would help investors understand the Nigerian oil and gas sector. The NMDPRA, as well as consistently, in line with the provisions of the PIA, engage with stakeholders, not just lawyers, not just practitioners, even investors, both local and foreign investors, to contribute to some of these regulations to ensure that they truly capture the intention and where they would love the sector to be. Importantly, given the long time and the experience of the regulators in the power sector, We've seen the agitation of most state governments to say we now want to be independent, to be able to regulate our own power sector, and definitely the constant engagement with the regulator, and with a regulator that has sufficient experience in the private sector. We saw the amendment of the Constitution leading to the enactment of the Electricity Act in 2023, and now we have over 11 different states creating their own electricity market. So it's important to mention that creating your electricity market is not just enacting the law. It actually entails you recognizing that you have different private sector players that can now compete within your market, and your market must be ripe enough for that competition. So on this one, I think it's critical to commend the regulators for all of the work that they've been doing. So at this point, some of the things that we need to consider as regulators, and that would encourage the growth and the type of investment that we want to see. It requires a level of transparency and efficiency that whilst you are being instructed by foreign clients or your foreign colleagues to say, what is the duration for us to start negotiation and get to completion, you have to be definitive. Unfortunately, like they say, two things are constant. They say debt and taxes. But if you're a transaction lawyer in the energy space, you always remember that one thing you have to include in your transaction documentation is that everything is subject to regulatory approval. It's one thing that you get other general regulator approve your deals, but your sector regulator also has to ensure that they begin to support lawyers and transaction advisors to quickly close most of these deals. Recent experience, we're advising a client on a deal, and the foreign lawyer said to us that, yes, I mean, we've done like 3 deals within the period in which we are negotiating this transaction. And they asked us one question: can you confirm to us when you think the regulatory approval will be procured? And when we were in the room in London, we just laughed because it was a very difficult question to answer. Whilst you continue to defend your regulator and you remain patriotic, it's also important that we get that level of support from regulators, that there's some level of efficiency and some level of predictability with deals. And most recently, we filed an application, something that you would think would just be a routine application to say, can we procuring a letter of good standing? You would imagine that that shouldn't take you more than maybe a fortnight from when you've written the application. The first thing is that you do not get the right response immediately. And when it comes back to you, for some of us, thankfully, you've been long enough in the sector to understand how to find a workaround. You then have to engage them, and thankfully, you would get the response that you require. But we need to get to a place where all of these processes are seamless, whereby you can write an application today, you are definitely sure that within a few days, you get a response, and then after paying the processing fees, all of this will be sorted. Again, mindful that some of these regulators now have issued their fees, schedule of fees. So if you're paying huge amounts of money, we believe that some of this should trigger and help fast track some of the processes that, you are filed. This is not without giving credit to seeing how both the L.E.I.C.A and the NMDPRA have tried to operationalize the PIA. We must give them a lot of credit. We know how long it took for the PIA to be passed and signed by the president in 2021. Give them a lot of credit, and we see that they consistently comply with that law, and they continue to regulate it. Importantly, one thing that gives most investors confidence every single time you're on a deal is that beyond the law and the regulations, there must be that level of consistency to say, if I need to do a deal, I go straight to the NUPLC website. All of the information I require are there. If there's any delay on the side of the applicant, you know that you're definitely the one who hasn't filed all of the requisite documentation. So it's clear to everyone to know that January 1 application in, end of March, you would get regulatory sign-off. Some of this would help investors to be able to quickly get to their FIDs. Because when an investor is coming into Nigeria, they want to be clear of all of the regulatory risks. And one risk that is always top of mind, when they draw the entire risk metrics, you always find regulatory red. And then when they turn to you as an advisor, what you say is that you can only give an estimate. So I think it's important that as a nation and as a sector, we need to move beyond just giving estimates as to when approvals will be procured. We need to start moving towards a definitive timeline for when things should be done. Interestingly, the PIA, both PIA and the Electricity Act gives you that regulatory comfort to say, if I do not come back as a regulator, you have a deemed approval. As interesting as that may sound, most people will still say to you, maybe I start moving with deemed approval. But the challenge with that is, as an investor, seeking to invest in a target, and target says to you, have deemed approval, you still will have some sort of level of cold faith. So it's imperative that we work together, both as practitioners and as our regulators, to drive that sector forward. And the way to do that is to ensure that there's a level of efficiency and there's transparency around that process. So lastly, it's important to also mention that as custodians of our law, is beyond just, we don't want to be seen as gatekeepers. We want to be seen as catalysts for growth and development in the energy sector. And this is very critical because when we see the decisions that IOCs are making around investments, as mentioned by the former country leader of SPDC, he mentioned it very clearly. IOCs have capital. They will only deploy the capital to countries that have investor-friendly regulations. And we saw when they made the decision around Guyana, the capital was available, they could have deployed it to Africa, but they rather made an FID to go to Guyana instead. We need to begin to attract these people. Our regulators may also consider having roadshows where they invite investors and tell them steps have been taken in industry to encourage development and growth as well. We see the reforms, and the reforms are very welcome. They are very, very positive, as we've seen in both the oil and gas industry and the energy sector. The energy sector, we see the regulator issue consistent regulations to provide clarity on different issues that are bordering both practitioners and all players in the sector. So on this note, I think I would hand over to the moderator so that we at least would find ways to engage with the regulators and find a collaborative way to continue to move the sector forward and ensure that we give the investors some level of confidence to bring in their capital and then deploy and invest in the energy sector of Nigeria. Thank you, everyone.
Good morning, distinguished ladies and gentlemen, Chairman of the Board of Trustees. My name is Jumoke Fajemirokun once again. I'm a partner at ENR Advisory, which is an energy law firm, energy-focused law firm. And it's my pleasure to be moderating this first panel. The theme is Law and Leverage, Repositioning Nigeria's Energy Sector Through Reform, Regulation, and Results. So the title captures both our challenge and our opportunity. The challenge is that we've made remarkable progress in reforming the legal landscape for the energy sector. We've had the Petroleum Industry Act in 2021, the Electricity Act in 2023, the presidential directives and various initiatives. And while we've seen some progress, it's not at the level that I would like to see at this point. So implementation still lags behind. The opportunity is that we can use these same laws as a leverage. These laws can also be instruments for investment instruments for innovation, and instruments for stronger accountability within the sectors. If we get this right, then it now goes beyond the rules without beginning to see real results. So to me, repositioning the energy sector means moving from policy ambitions, moving from reports on paper, moving from great laws to real outcomes. And that ensures stability, it ensures that the framework builds confidence, and then results are tangible. We see more investment, we see broader energy access, and we also see stronger accountability. So LEICA has done a very good job in setting the scene, and the keynote addresses the goodwill messages. We see very clearly that investors are focused on what the regulatory regime is, how predictable it is, how consistent it is, how clear it is for them to be able to make those significant investments that are necessary. So in this session, we have very distinguished personalities in the legal landscape, both from the public sector and the private sector. We have our regulators, senior legal representatives of these regulators, and the private sector as well. And I'm looking forward to a very engaging conversation on how we can use our laws to leverage prosperity and development. So to kick off, I would just like to throw this question open to all the panelists. When we talk about repositioning the energy sector, what needs to shift right now? Is it the laws? Is it the institutions implementing these laws, or is it just the mindset that shapes how these laws are implemented? And I'd like to start with Dr. Tolorishe, and we'll then move on to the end.
Okay. Thank you, Jumoke. Your question is very apt. Let me just answer it straight away. I think both the law, the mindset, and the third one?
Institutions.
Institutions. Yeah, we have the law. The question is the law really very clear enough? Is it easily interpretable? Is the language very plain for ordinary man, not even a lawyer, to interpret? Looking at the PIA, is it very clear enough? Are there ambiguities in the PIA? What are the intents of those provisions? You know, from my own experience, you find out that PIA is a compendium, you know, containing over 300 clauses, sections. So it is not, it is possible there will be some kind of ambiguity in the PIA. And what do we need to do? We need to understand it. We need to understand the intent of that PIA and try to implement it in a way that will be friendly to both the government, the operators, and even the investors. So you need the law to be very clear. And where it is not clear enough and you need to do more, it's either you seek for amendment, otherwise it will lead to dispute. And we have had several disputes concerning PIA. We have about 3 or 4 cases, locus classicus, that is very novel regarding the interpretation of the PIA. And that is to say that the PIA needs to also be very clear. The legislature needs to make it very, very clear. Then the mindset really has to do with, are we ready to change? Because PIA has introduced a lot of changes. It's not unlike the former Petroleum Act, the way we do things. Here, we have 3 distinct sectors: upstream, midstream, downstream. You know, how this upstream, midstream, where does midstream end? Where does upstream end and where does midstream start? Down to the downstream. So you must have a clear understanding of this particular thing. If you don't have understanding of it, and that's how PIA is fashioned, then there will be a problem. So, and in that process, there are a lot of changes. You know, you can no longer have, by PIA, you can no longer have a single company that will run the 3 streams. You have to register separate entity for each stream. And for each of your license activity, you have to get a license. So if you are having one license in the upstream and think that it will run you through to downstream, that is not right. So we need to have a clear understanding and be ready to change, along the provisions of the law. We talk about the fiscal regime introduced in the law. There are new things that you really need to understand. Then the institutions. There's need for alignment between the institutions. The institution really need, that is the regulatory institution, they really need to collaborate to understand their individual roles, where it starts and where it stops, so that we don't create confusion and overlapping functions. So the institutions, the two regulators need alignment. When you look at the provisions of the PIA, a very contentious provisions between the two institutions is the issue of integrated operations and integrated facilities. They have interpreted it differently, although the government has come in to try to come out with directives. That is the current administration. Came up with 2 directives to make sure this is streamlined, your individual role. But the 2 regulators must be ready to work together and abide by that. So predictability is very important. I know it is out of place for you to come with, after passage of the law, you are now coming with directives to change it. Lawyer will frown at it. But that's the station we find ourselves. So for repositioning, what we need to reposition, we need to also look at what is the current state of our law, the people that are implementing it, and the institutions that is also implementing it. I don't know if I will go on.
No.
You have more things to say.
Yes, you still have more things to say. Well, thank you very much. I think you really covered a whole lot. It's important that the rules are clear. And if they are not clear enough, if they're ambiguous, then we should be dynamic enough to quickly review those ambiguous provisions. The mindset is very key. This new regimes have brought up changes that are really more like tectonic shifts. And if the mindset doesn't move accordingly, then we don't get proper implementation. I'll move on to Commissioner Dafe. And may I just ask that we just spend 1 minute each so that we can move on to the next questions. Thank you.
Okay. Good afternoon, everybody. I think as Nigerians, that is a very difficult question to answer. And really, as a country, when you look at our body of laws, there are very few pieces of legislation that you look at and say, this law is very inadequate. Like what we saw, the shift from the Electric Power Sector Reform Act to the L.E.I.C.A Act. And there are very few laws that fall into that category. And let's take the laws for traffic and driving. The highway code, Nigeria's highway code, is similar to that of the UK and the US. Similar piece of legislation. But what results do you see outside? Right? How is it being implemented? Right? Same piece of legislation. The only difference between ours and what you find in the West is they will make provisions for hazardous driving due to weather, winter and things like that, which we don't have. But principles are the same. But are the results the same? No. So it's never an issue of law, right? I belong to the Roscoe Pound school that law should be a means for social engineering. And the law cannot go beyond what society wants, right? If people choose to act in a particular way, no law can supersede that, right? I think people in the room here travel, and we've used Uber and Bolt in different jurisdictions. Nigeria is the only jurisdiction I know that when I land at MM2 and I book a ride, the Bolt driver tells me that the price he's going is not the price on the app, right? And we now get into a negotiation back and forth. And if I'm not pressed for time, I'm not rushing, so if I get into Lagos on a Saturday, I will counsel and keep calling because I don't think that is the right thing to do, right? And after doing that, they'll tell you, they charge us the X percentage, they do this, they do this, they do that. But that is the reason why you signed up. And you're not just driving around waiting for people to call you, right? They do that, and after that is done, when they start the trip, they still do not activate that trip on the app. So meaning they've done a ride without any revenue going to the owner of the platform. I say this just as a backdrop, that you cannot outperform a people. And as a people, we need to have a collective mindset of what it is we are seeking to achieve. Then the laws will follow it, right? So we have polygamy. Bigamy is a law in Nigeria. Has anybody been convicted of marrying more than one wife? I think all of us have relatives or come from homes that are polygamous in one way, shape, or form. So it starts at a central mindset level. What is the purpose? What are we seeking to achieve? Right? And I've listened to the openings. People have spoken about investment. Investment isn't about a foreigner coming into your jurisdiction. It starts with you believing in your own jurisdiction itself. So typical example, the Ethiopians built the largest hydro plant on the continent of Africa without a dime from anybody outside Ethiopia. Right? So without a contribution from anybody outside Ethiopia, the Ethiopians themselves came together, saw it as an obligation, and they put money, diaspora funds and things, and they built that dam. So as a people, we need to define what matters to us. And how do we go about achieving what truly matters to us, right? Nigeria is the only country where I've been to that I sit down with a group of lawyers, and lawyers want your laws to be as prescriptive as possible. It doesn't happen anywhere. The US Constitution, as a new lawyer, I went to US Supreme Court. What is the requirement to become a Supreme Court justice in America? You are nominated by the president and confirmed by the Senate. Only two in the US Constitution. Only two. Juxtapose that with ours. Must have been a lawyer for 15 years, nominated by NJC, blah, 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 blah. But when you look at the abode benches, right, which would you say, right, is meeting its purpose, right? They've existed for longer, and because of the way their laws are drafted, they're able to evolve. So they don't have a fixture. You're not in a straitjacket. So I think what matters is we shouldn't phrase the questions like that, right? We need to phrase the questions around the frameworks about what really matters to us as a people. And what are the fundamental things we need to do to achieve it? Because I really do not think that the problem is our law, because we've seen in Nigeria, whereby we had a serious constitutional problem. And when we knew that something was important, we said there's a doctrine of necessity to solve that problem. So we need to decide truly what matters to us and decide the frameworks that will suit Nigeria to solve that problem.
Thank you very much. I think that was a very important perspective. And I particularly take the phrase, the law cannot go beyond what the society wants. So it's really a fundamental mindset shift that is required. And that really, it's a conversation that will go on for weeks. And I think it's something that we need to take away and reflect on it and just, understand how we can do better as a society, how we can understand what it is that we really want, and how we can define the rules that really work for what we really want. I'll go on to Lois.
Okay, all right, thank you. Maybe I'll just build on some of what has already been said, because I think it's clear that we really need to look at all three. They're interrelated. It's not a question of one over and above the other. But when I look at the laws, what we're thinking is more along the lines of how do they enable business? Are they about enablement, or are they about control? The control era, when we're trying to struggle with resource management, I think we're way beyond that now. The global world we live in, and being in the sector that drives everything, what we need is frameworks that enable business competitiveness. So when I say frameworks, I'm thinking of the regulations that support the laws. We're thinking of the implementation. We want business competitiveness, we want innovation, we want sustainability. I think that's the only way we can enable this sector or empower the sector in Nigeria to be the best at the global level. When you think about our regulators, it's also about them enforcing and implementing with a more collaborative approach. So if you're moving away from control, then the conversation is a bit less about policing and more about partnership, maybe oversight through partnership. And I think one thing that is clear at all levels is that the governments can't do it alone. So we really need public-private partnerships to be able to achieve what the organization's goals are. And of course, it is underpinned by the mindset. The mindset needs to look at what we need. It needs to be results-driven. It needs to be that, how do we reduce bureaucracy? How do we remove blockers, What's the big picture for the nation that we're all working towards? I think if you can align all three, the policy, the institutions, the behaviors, then you can actually build the confidence, which I think you mentioned earlier, in the system, because all parties are then pulling in the same direction. Thank you.
Thank you. So it's less about policing and more about partnerships and building the frameworks that allow for those partnerships to happen. Thank you very much. Mr. Chikwindu.
Okay. Thank you very much. For me, the question is repositioning the Nigerian energy sector. I want to look at it, from the point of view of outcomes, really. You want to reposition something. That means there's something that is existing, either you want to go away from it. So let's ask ourselves some of the fundamental questions, because we are talking about the energy sector in Nigeria, right? I go everywhere and people talk about predictability of laws and all of that. You take the Nigerian energy sector. It's been a very predictable one. Petroleum Act 1969, the NEPA Act and all of that, and we're talking about 2023 and 2021 when we have changed the law. Now, the kind of outcomes that you have seen, in these past 30 or so plus years that I've been dealing with are the kind of outcomes that were embedded in that law, right? Now, the country has taken a bold step, to change the framework, announcing a different direction and therefore different outcomes. So already, the country has started taking the very positive steps towards achieving that. So you see the Petroleum Act seeking now to make rules that expand the industry, make rules that make it possible for us to develop the mainstream sector of the economy where you can actually, create more for the economy. Before, it was more like produce and export crude oil. So, and that's under the Petroleum Act. And now you have this whole reform. You go to the electricity sector, the same thing. You're coming from a regime of state control where you had NEPA and all of that. We did the first initial phase of the positioning when we privatized. And now the 2023 Act now has come in place that now has set up a framework for us to begin to work in a different direction. In my view, and I understand the need for us, the world is, and we're in a hurry, we want to catch up. I want to believe that what we are going through following the passage of the 2021 Act and on petroleum and the 2023 Act on the electric sector is a journey. We are still at the very early stages of it. And some of the results may not be very tangible, but if you've been part of reform, the way we have been, we're seeing a lot of changes. You made mention about changes in mindset. I will give you one critical example. Dr. Tolosha alluded to that. One of the major key challenges that we've had so far is this seeming misunderstanding between the Midstream and Downstream Authority and the NUPROC as to the extent of roles and responsibility, in the midstream with respect to shared institute facilities. Now, it wasn't as if the planners of the law did not anticipate that such implementation challenges would not occur. That was why, at the point that this law was being made and institutions were being set up, the law said, okay, that the chief executive of the authority will be a member of the board of the NUPROC and vice versa, because there must be implementation challenges. And until you start implementing, you will not see those challenges. So, unfortunately, you cannot decree reform of the mind. It takes a while for it to happen. So, my view is that thus far, I think the country is on the right path. The laws might not be perfect, but I want to believe that the laws that we have so far, signaling the aspirations of the country towards these new outcomes, they are adequate. There's still room for improvement. And the institutions as well has been reformed. Now we have the NUPROC with greater independence and greater autonomy, to take certain decisions and to act independence of political interference. Likewise, on the downstream side, and the human element of it, which is change, the way we behave and all of that take a lot of time. But I want to believe that these rules that we have set as we walk this journey, that we will continue to make improvements and progress. Thank you very much.
Thank you very much for that. So we're on a journey, and the journey takes time. And with the steps we're taking, I think what I hear you say is that the foundation that has been laid will make that journey take us to the desired end. So I'll take L.E.I.C.A.
Thank you very much, Jumoke. I think from the law perspective, a lot has been said. But it's important that there's a change in mindset. And I'll give a very simple example. Before the reform that was implemented in the electricity sector, you find that when light is restored, people shout up NEPA. And people did not think it was ideal for them to fully pay the tariff being charged by the discos. So they saw electricity as some sort of welfare that government must provide. We begin to see that mindset shift in the electricity sector. It took a while, but gradually we're getting there. Where when you receive your bill, people just prepay now, and some people on band A pay as high as over 200 naira per kilowatt hour. You see less complaint now, right? Because people now understand that electricity is a service, a utility that has to be paid for. So the mindset needs to get better. On the law side, honestly, we must commend the three regulators for the incredible work they are doing. NUPROC this year, after several engagements with them, to confirm what the fee payable for assignments will be. They knew that it would take a while to have a full stakeholder engagement. What did they do? Simply issued a temporary upstream petroleum fees and rent regulation to say we will issue this temporarily until you are able to fully engage all stakeholders in the sector to determine what those fees will be. Of course, some of the fees we agree with them, maybe not. And that's where that collaboration comes in, where we continue to engage with the regulators to ensure that we get to where we want to be. Of course, we're witnessing the evolution in the sector. The important thing to do is to continue to monitor that, concern engagement, and as advisors, experts in the industry, people who have significant experience, to continue to put in your papers to help the regulators. They will not know everything. They are there as custodians. They are there to win the trust of not just the players, the trust of everybody involved, all players in the sector. That way, I believe that we can find a way to reposition the energy sector and get to where we want to be, and definitely we will have the desired result.
Thank you very much. The mindset shift also rings in what you said, and you've also thrown in the need for collaboration to get that desired outcome. And so I'll go back to Lois. So we've had these reforms. Everybody is aligned in the fact that we've seen some progress in the sector. We've seen more investment come in. Dr. Kumbo also referenced the very important FIDs that we achieved. What would you say are the gaps that still remain that hinder investment into the sector?
Thank you very much. And I think one critical thing Dr. Okumbo mentioned when he was talking was that we also need to bear in mind we're competing for a limited pool of funds, and the amount of funds required for investment in this sector is massive. You're always going to be talking about hundreds of millions or billions of dollars. So we need to be looking beyond our industry, and what we need to be doing is making ourselves attractive, right? That's what our framework needs to help us do, attractive to the funding, so that we attract the money that is required. We've heard a little bit about regulatory uncertainty, so I won't build on that too much. But I think that the overlaps extend beyond the apex regulators. The issues have been already spoken about, between the commission and the authority and what's being done. But we also have situations where there's a multiplicity of the regulators coming for the same thing, So we deal with the authority, for instance, the apex regulator for the midstream. Very simple example, environmental compliance monitoring. So the authority, we do environmental compliance monitoring with the authority. Not too long after that, you'll find we'll do it with the Federal Ministry of Environment again, and that's even fine. But then you'll now have 2 or 3 others. You might have NESRIA, someone else coming in and saying environmental compliance monitoring again. How can we assure investors that we're in good standing, good regulatory standing, if that goalpost is not certain? A single source of truth in that area is something that would be really, really helpful. I think the fiscal policies as well, somehow it's not really just the energy frameworks that will impact that as well. Because again, when the money comes in, the money needs to be working. It can't afford to be stopped. So when we talk about bureaucracy, I think a mention was made earlier of the Business Facilitation Act. It was recognized clearly that we need to do better in our timelines, in increasing efficiency, because sometimes, again, the time is passing, and again, when you're in competition for that pool of funds, if you're not ready, it just goes somewhere else. So we need to be able to address those to have confidence in our system. We talked about the enforcement mechanisms earlier, so I won't go to that, but I will speak a little bit on what is seen as the burning issue now, which is the energy transition, right? Nigeria's position on the energy transition, we took an approach where we set a target, net zero by 2060. We have the emissions transition plan. We committed to a 32% reduction in emissions by 2035, I believe. We also said there'd be an increase in the share of renewable electricity generated from renewable sources, I think from 22 to 52%. I don't recall the timeline for that. But I don't think there's a lot of visibility on the progress that has been made. And that makes investors who, again, must show that their portfolio goes to clean energy, clean investments. It makes them pause. It makes them take a watch and see or a restrictive approach to the amount of funding that will be able to come in. And then, of course, there's the carbon market approach. It's in various frameworks that we have today. But again, what's the progress on the implementation? I think those are gaps that if we could address them could make a difference. I know there's a conversation around, so it's the polluters that are driving for the energy transition now because they've developed themselves. And I know that we have to use what we have to solve our issues, but then we have gas. How are we incentivizing investment in gas? We keep asking the question, there's a lot of oil exploration. There's not a lot of gas exploration. And that's a very rich area for Nigeria because we have a lot more gas than we do have oil. Not only is it a rich area, it's an opportunity because globally, gas is the fuel of the transition. So how can we put in place frameworks that incentivize gas investments, monetization of gas, and use it not only to meet internal energy requirements, but also to meet the global revenue requirements, because we're in a great position to sell that energy to the world. I'll stop at that for now. Thank you.
Thank you very much. I think you've highlighted a number of gaps that need to be addressed, very important gaps. But now I want to move on to how regulation takes place effectively, because you then have the law, and the next thing is how is it applied. And you also talked about the misalignment in coordination amongst the key regulators that you have to deal with. And so I'll take this question first to Mr. Chikwendo, and then I'd like Commissioner Akpene to respond as well. How empowered and coordinators, how empowered and coordinated are the energy regulators to ensure a stable, transparent, and predictable operating environment in Nigeria?
Again, this raises the question of what's on paper and what do you have in reality. Clearly, the two very important legislations we are talking about here, the PIA and the Electricity Act, clearly created independent institutions. In the case of the upstream, in the case of the petroleum sector, you have NNPPRA and you have NUPROC as the major regulators. And these, on paper, are supposed to be independent regulators. The Act even further went ahead to ensure that they have funds, independent funds, that the funding of their operations is guaranteed by the law. Now, whether that has, in reality, translated to the kind of independent action, that we would expect. Like I mentioned, it's a journey. We have started implementing. I want to believe that as the regulators under this new arrangement do their work and implement these laws, we begin to see, the result of that empowerment that has been built into the law for them. So, in principle, the regulators, both under the Petroleum Act and under the Electricity Act, are empowered. I want to believe that they have sufficient empowerment, in terms of their independence, in terms of restriction from undue interference, in terms of personnel and independent decision making, as well as funding. And so I believe that the law on that side is adequate. So what we then need to see is how these regulators take on this responsibility and discharge their functions, in accordance, with the principles of independence that they have in the law. Yeah.
Thank you very much, Commissioner Dafe.
What's the question?
The question is, how empowered and coordinated are the energy regulators to deliver on a stable, transparent, and predictable operating environment? And maybe you could also speak to coordination as well, because you're now having to deal with state-level regulation.
Okay, so to exist in government, you need a lot of level of coordination. Bearing in mind that in the executive branch, which we work, only one person is elected. And he now appoints different people to take care of small activities. And no activity can be executed on its own. So I work with the electricity regulator, right? Over 80% of our feedstock for electricity generation is gas, right? So my sector has a serious co-dependability on the gas price, which I do not control, which NERC does not control. So even when the frameworks were loose, as at 2018, 2019, still under the old piece of legislation, NERC set up a working committee with DPR that how can we, within the frameworks we have, work together to meet the requirements of our mandates, right? So you need to partner, because no matter where you sit, government exists for welfare and security of people. So you must have that collaborative approach. So you need to understand that you can't do it all on your own, and you need support. Because even decisions you take in one part, right, has far-reaching implications. So you need to consult not only within your sector, with players outside your sector. Any decision taken on the gas price, I'll give an example. The gas transport code, right, had serious implications on our sector, and we had to write to the regulator on the other side that, look, gentlemen, see, these are the implications on our side. So you need to have that. Each of you needs to know what the other is doing, so you can achieve what you intend to achieve. Then from a legal standpoint, from an empowerment standpoint, which you notice what I said in my opening, I'll speak about our law, right? The law that established us, the Electric Power Sector Reform Act, was a law that was tailored towards a reform and not having a regulator in place over an industry. And that was the very first thing I noticed when I resumed in 2017, that, look, we need to change this law. But even within the constraints we still had in the law, it didn't stop us from doing actions that needed to be done, right? And we went ahead. There were a few infractions that we saw, that we knew that, yes, we don't have the powers to do this, but what does the law allow us to do? And we exercised it. Initially, the Federal High Court said no, and the Court of Appeal reaffirmed the decision we took. So you must understand your system. Right? You're not going to get everything you want in a piece of legislation. You're not going to get everything. But you must know how to work within, use the vehicle of the law to drive your industry in the direction that it ought to go.
Thank you. So, I mean, we see that empowerment, first of all, the regulatory independence, as well as coordination and collaboration amongst regulators is very key. And also the mindset of innovation, so that, you can, in between the gray, you can achieve what you need to achieve, even if the law doesn't specify those exact things. So we've been focusing on creating the environment for investors to come in. We haven't really quite talked about the consumers. So I'm coming to you, the energy consumers, that is, Dr. Tolorishi. How can regulators strike the right balance between market liberalization, encouraging competition, as well as protecting consumers from poor practices, predatory practices, and availability?
Thank you very much. Talking about protecting the consumers, against sharp practices. Again, I will refer to the Petroleum Industry Act. The PIA has made a very copious provisions relating to setting of tariffs, setting of prices, prices framework, and then taking giving it power to investigate abuse of dominance in the industry, especially in the downstream space. What it means is that the authority has been given power to prevent monopolistic tendencies. And you don't even wait till when it happens. You have to, when you see the trend, you can quickly investigate and then be able to take a proactive action. To talk about price predatory also, the regulator is also empowered to check that. And NFDPRA has been working closely with FCCPC, that is the Consumer Competition Protection Commission, regarding some practices in the downstream space. What we have been able to do is to ensure that, let me even give an example of product refining now in the downstream sector. We know that presently we have private refineries. And the dominant one is the Dangote refinery, right? Then we have other private refineries, about, I think there are about 7, if I'm correct, 7 or 8. So, but those ones, they are modular refineries. And what they mainly produce is AGO and the other products, but they don't refine PMS. Dangote refinery presently is only one refining PMS. The other government refineries are not operating optimally. So you find a situation whereby it's possible that you might have a dominant factor setting up. So in that wise, the PIA has actually made provisions how you can how you can come in. That where you notice that, we have a dominant player or a monopolistic tendency, that you can begin to regulate the price of that monopoly. The PIA is very clear to that. So those are those safeguards in the law that can prevent abuse of dominant player or monopolistic tendencies. So currently we're doing that. We have had meetings with FCPC, and they have agreed, and they have told us that, well, currently there's no monopoly. To them, that there's no monopoly. We don't have a situation of monopoly yet. So that if there's a situation of monopoly, they have safeguard in law to check it. So you might be hearing some kind of a lot of problem in the recently where the Pegasus wanted to go on strike and all that. So but the government has stepped in to prevent that. So then again, we've been cooperating with the Electricity Regulatory Commission, especially in setting up of gas pricing, which was mentioned by the commissioner. You know, the NMDPRA is empowered to announce the gas pricing framework for GBIs and other commercial something. And by April, we're supposed to come out with that pricing. But before we do that, we do L.E.I.C.A cooperate with the Energy Regulatory Commission because we have a handshake. We have to get the price right. If we don't get the gas pricing right, definitely it will affect power sector. If the power sector is not paying for the right price, definitely the gas producer will not produce. So you have to strike a balance and make sure that you have a pricing framework that will reflect the cost and then allow for margin, at least margin for the producers. So in that wise, we are also trying to balance the producers, the power generators, and even the consumers to make sure that, yes, because the three are linked. If we have problem with one, definitely it will affect the other two. So far, we've been able to protect the consumers. If you look at the current prices of petroleum products being sold, you see that initially it was high, coming down. So it's not really certain because we are in a deregulated regime. So you'll be having, today it might be high, tomorrow it will be low. So it's reflective of what is happening in the market, even internationally as well. So we have been able to do that. But when you look at our refining capacity, like we said, if you look at the capacity of the refineries we have today, if we combine all the capacity, installed capacity, it's about 1,200 billion meters per day. About 1.2 million meters per day. If you look at their installed capacity, but they are not meeting it. So maybe about 50%. That's what we can meet. So how do we now balance the rest so that there will be no product scarcity? So what it means is that it's possible that we might still allow importation to substantiate it. But when you even look at our consumption, before PIA, before the regulation, the consumption of petroleum products, you that is, look at what is being announced. It's over, tell you it's over 60 million, 70 million per day, liters per day. And now we have average of about 50 million liters per day, 49 to 50. So it's also coming down. That means that smuggling is coming down because of the deregulation. So with all this, the consumer is having a fair price. The producer is also having a cost-reflective pricing system that will enable them to afloat on business. So those are those measures that the regulators has been taking to ensure that both parties are protected fairly.
Thank you. The balance is really key, and I think one of the ingredients to making it work is a system where there's transparency and regulatory enforcement is consistent. So I'll take this question to you, L.E.I.C.A, and I'll just ask you to be very quick in your response because, as you can see, we're out of time. How can greater transparency and consistent enforcement of regulations help rebuild investor confidence and trust in the sector, as well as for the consumers that are the beneficiaries of all of this?
Okay, thanks, Jumoke. I think the first thing with building investor trust is building the investor confidence. And how do you do this? Transparency starts from you being clear as to what the laws, regulations are, and what the penalties are when you flout those laws. Once all of that is very clear, investors are able to manage the risks better. Because once there's uncertainty and the laws are not clear, then you leave a lot of things to speculation. Most investors will not thrive in an economy where there's no certainty of law and where there's too much unpredictability around enforcement. To drive investor growth, the country itself needs to be investor ready. And what do I mean by investor ready? We've seen the attempt by the government to encourage investors, issuing executive orders to encourage investors to say we're now moving to an era where we're going to be more investor friendly. Those attempts will encourage investors, and some of the speakers I've actually mentioned earlier, that some of the reactions from those IOCs have been positive. And we saw the evidence just last week where the gas investment by FID investment by Shell was announced, and a few months ago they also announced the one from Moga as well. So the moment you have clarity as to what the rules and regulations are, definitely investor trust will be built off the back of that. But without that being the case, where, for example, you want to apply for licensing, the processes are not clear, you're unsure as to what steps you need to take, what the fees are, then it becomes very, very difficult to build that level of trust. And trust is built on a process that is clearly transparent, and there's accountability on the part of the regulator to say, this is what we've issued out, we would ensure that this is complied with. Once there's that, compliance is a lot easier. But where there's speculation, definitely will be difficult to build investor trust. So on the back of that, transparency is very, very important for repositioning Nigerian energy sector. Okay,
great, thanks for that. So where there's trust, where there's transparency, there's trust.
Definitely.
And there's accountability, and accountability then drives compliance. I think that's very important. That's a very good way to just end or pause the conversation on this panel and take it to the audience. Thank you very much for paying attention. May I just ask if anyone has questions? We'll take just one or two questions because we're out of time. Okay, so we have the gentleman in white over there. Is there a mic there? Okay. So it's the same table.
Hello. Okay, good morning, everybody, or good afternoon, as it were. My name is Olu Phillips. Mine is a bit of a contemplation, and I'm not sure who might be able to give an explainer to my concern. I'm just going to, because of time, narrow it to the issue around the downstream petroleum sector. a little back in history, not very many people know that what became the Local Content Act 2010 used to be a piece of legislation, or a piece as part of the PIB, which the former Minister of Petroleum Resources, Desiani, had to pull out as a document, take to the president, and get that signed off. How to understand the impact of that is when you look at the portfolio of the Nigerian content today, it tells you what a piece of legislation can do when you take it from presentation to actual work. Today's downstream oil sector has become a bit more confusing for me after the deregulation of the sector. So there are issues around whether we have a monopoly in the downstream oil sector. There's the issue as to whether the NMDPRA is confused of what to do or has been caught in the middle of the act of what should be done. Now, this concern borders on, in the bid to grow Nigeria first, or in the bid to grow the sector, vis-a-vis what the law says, are we pandering towards an unexpected direction in terms of what that law was made to achieve, or the problem is with the implementation of what the regulation that has been canvassed for over 20 years? Because practically, it's working in a reverse mode when it comes to the implementation of what the deregulation is meant to serve. I don't know if we can get more clarity from anyone on what the sector today is when it comes to the deregulated downstream sector. If you take into consideration that members of Koran, for instance, those who have refineries that we refer to as modular refineries, and vis-a-vis the big refinery, do we have a level playing field based on what the law says?
Thank you. I think Dr. Tolarishe can take that question. But before that, I'd like us to take the second question so that we can then turn it to the panel. It's the same table.
Good afternoon. Hello? Good afternoon, everyone.
Is there a better microphone?
It's working.
Good afternoon, everyone. My name is Ibukun Konu. I'm a lawyer with Streamstars and Cone. We've heard quite a lot about regulatory interface, and picking on what...
I'm sorry, the microphone is not very loud.
Hello?
Okay, it's better.
Okay. Good afternoon, everybody. My name is Ibukun Konu. I'm a lawyer with Streamstars and Cone. And I was saying that we've heard a lot about the roles of regulators. And Dafe mentioned that, we have the law, but that it's what is the intention of Nigerians as a whole, as a state. And L.E.I.C.A also mentioned about mindset and, what are we trying to achieve. But I think to ask that to Dafe, don't you think that there needs to be a driver, even where there is a national consciousness or a national feeling? Don't you think that the government needs to be the driver through the regulators? And also for L.E.I.C.A, when you talk about mindset, I don't think mindset is enough, because I don't think mindset goes without compliance. To take the example that Dafe gave, if you talk about the codes or highway codes, for example, the reason why people will adhere to those highway codes abroad is because if you drive, you overspeed, nobody's going to stop you. You'll get your fine. You appear in court. you get points deducted, your license can be suspended, your insurance the next year becomes more expensive and things like that. So don't we need more technology to drive compliance? And to that way, the role of the regulators...
Like 3 questions.
Sorry, this is the last one. The role of regulators in making the law, because we've spoken about the PIA. I'm aware that there's a bill to start a decommissioning and abandonment commission separate from the NUPRC. We have the Electricity Act, and currently there are 2 bills to amend the Electricity Act at the House of Representatives. So how do we create certainty? How do the regulators intend to help in this process, though legislative, but how can they help to ensure that there's certainty in the market and we have laws that are not being amended so often or seem as if we're divided or we're confused as a nation? Thank you.
Thank you. Dr. Toronche, can you take the first?
Okay, thank you very much. Mr. Olu Phillips, if I get your question correctly, the status of the downstream presently. Okay, let me take it from the midstream. Like I said, we want to know what we're doing presently. We are not confused. We know what we're doing. Right? Let me take the refining operations. Like I said the other time, we have about 10 refineries, in Nigeria currently. We have about 6 private refineries, and we have 4 government refineries. The combined capacity of these private refineries is designed at 679,500 liters per day. That is their design capacity. Dangote alone is 650,000. Others are modular refineries or smaller quantity. While the government refineries, we have the four refineries, their combined capacity is about 400, just a little bit above 400,000 barrels per day. But like I said, we have issued licenses to these refineries. Some of them, they have LTO. The list of them is LTC. They are meant to operate at their maximum capacity. But what you find out that they are not doing that. For example, especially the private refineries, they are not operating at their full capacity because they need availability of crude as well to be able to run this. Even Dangote himself needs availability of crude to both locally, if he cannot get it locally, he needs it abroad. And what have we done regarding that? We've been able to enhance that through the government by this backward integration policy in the downstream, whereby we have local currency trading of crude and petroleum products. Presently, Dangote enjoyed that. He buys crude in Naira, and that's why he's selling crude. The product is imported to Nigeria in Naira as well. So we've been able to support refinery operations, and thereby in doing that, we've been able to replace import of PMS by 50%. We'll be able to reduce it. We'll be able to ensure that L.E.I.C.A is also produced 100% locally, and AGO as well. About 70% of the AGO are produced, that are imported, has been eliminated. Also, the tanker truck safety as well. When we move to downstream now, we introduce anti-speed safety measures on tanker trucks, because at the point we found out that you find tanker truck accident here and there, bursting into inferno and killing innocent people. But we have introduced that anti-spill safety measure on the tanker. We'll be able to reduce load carrying capacity of road tanker trucks. You find before, you see that a tanker will carry about 90,000 liters of PMS from Lagos to Maiduguri or to far north. We have been able to reduce that and say you cannot carry more than, we'll reduce it to about 45,000 liters. Okay. As time do not permit, maybe I will have a private session with you and tell you a number of initiatives that the NMT PRA has been doing in the downstream sector. So give us kudos. Thank you.
Thank you very much. So the second question, I know it was really, really loaded, but we have to condense it to one person responding. And you directed to Commissioner Dafe, particularly the different other laws that are coming out that are making the landscape less predictable. Decommissioning bill, you talked about some electricity bills as well, if I'm correct. Yes, if you can speak to that. Okay.
You asked, your question first was on the issue of accountability. And when I gave reference to the issue of highway codes, right? But I think you're looking at it a bit in a simplistic manner. And I'll give an example. I'll use my class WhatsApp group. We have a certain gentleman who's my classmate. We went to IFE together. He was the person who is the main advocate of merit. Everything you would discuss, merit. And as an institution, we ran what I would call the most transparent public sector recruitment that I've seen recently. Because we wanted anybody, you didn't have to know anybody to get in. And this same gentleman who is the merit advocate had a ward who applied. And his ward didn't get shortlisted. And he started disturbing me. And out of my way, I said, I'm going to find out what did this person score. I found out that this person scored 28 over 100. And I go back to the merit advocate of my class, and I said, oh boy, your ward scored didn't pass. In fact, it was too poor, 28. He now tells me, do something. And I say, do what? You understand? So that's the issue with mindset, that we should be prepared to accept that this is the process and these are the consequences of the process, right? I want electricity. Electricity is not a free good, right? It comes at a cost. No one is going to invest in the production of electricity if he cannot make a return. And if he's to, and that return must either come from, either you allow me sell it at the price, or if you want a discounted price, subsidize it and pay me the subsidy. That way, people would rush in, right, to do it. So set the rules and let it be clear at all levels. Second point, you made reference to the issue of the multiplicity of laws. First of all, it is the responsibility of the National Assembly to make laws. They have a constitutional responsibility. How frequent they want to amend and make laws, we do not have jurisdiction over that. But for the laws that relate to my sector, right, when I resumed as a commissioner in 2017, I found out that the Electric Power Sector Reform Act was very inadequate. This is a sector whereby you have the simplest investments, you're talking about millions of dollars. And the regulator had no fining powers, had no powers of deterrence, couldn't operate, couldn't steer the industry. So a lot had to change. And that's what we achieved with the Electricity Act. But in arriving at the Electricity Act, for those who've read the Electricity Act, will notice that there are grievous constitutional inconsistencies that have been committed in that act, whereby you have gone against the grain of the supremacy clause in the Constitution by saying a law, the Electricity Act, a law passed by the states takes precedence. There's no one would see that and say, no, gentlemen, let's fix this, right? And so there are things that have to be done, right? And there's a saying that all laws are due for review from the day they are passed. Because you look at the law and you say, wait a minute, there are one or two things we can do. What becomes a problem is where you are seeking to arrive at solutions that are academic, solutions that do not take into particularity the nuances of an industry or how the industry operates. So, typical example, in the old law, all licenses issued by NEC were for 10 years, max. But we operate in a project finance-driven environment whereby your financing is going to be tied to the length of your license. Because if you're not going to have a license to do what you are borrowing money for, why should I give you money? And you want a longer term. And the regulator may say, I don't like you. So what we proposed was that leave that at the discretion of the regulator. So those were one of the few amendments that were done. So the issue of laws, right, it's not the amendment that's the problem, but what the amendment is seeking to achieve that we should look at and contribute as Nigerians to that amendment process. And as a regulator, you ask the final question, that what do we do? Okay, so NERC sponsored the First Amendment, and we're also actively involved in this amendment of the Electricity Act in particular.
Okay. Thank you very much for that. Our time is fast spent. I think this has been a very interesting panel discussion. So many layers, so many issues have been raised. It could take a whole week to unpack everything. But I'd like to thank our panelists for their time, for the very important perspective they brought to the conversation, and to the questions we got from the audience from making it even more richer. So we have the laws. The key issues are around implementation, and what we see is that it's work in progress. It's important that we embed the frameworks that allow for transparency, for there to be greater transparency, which is what builds trust and confidence, and what encourages people to adhere to what the rules say. And also would like to see greater enforcement. I mean, the mindset shift is very important, but I think if we see enforcement being applied more consistently, then it really informs how the mind works. So on this note, I'd like to bring this panel session to a close. Thank you very much. And feel free to ask any questions you have during the break. Thank you.